There we go. Now we're recording. So we're going to talk about financial disclosures and conflicts of interest this Training Tuesday, rather than our other forms where we would walk through a couple if we had anything new to discuss, as well as if there were any new forms or new job aids. But today we're just going to focus strictly on financial disclosures and conflicts of interest. So I do have a slide. It's the most common corrections needed on disclosures, but we're going to circle back to that. So I want to open up disclosures on, let's see if I can make this a little bit bigger. So what I'll do is I'll walk through the form, and just going with the example of we have one vendor and there is one owner. And then we'll go back and we'll layer on that on top of that. So because you're going to end up having financial disclosures if you have multiple parents. So if a company is owned 100% by another company, you're going to have different sets of financial disclosures. Okay, it's not going to be one form that is completed by all of the ownership group. So I'll walk through a couple different examples, a couple of the most common ones we see, and then talk about the most common corrections that we see needed. So you can be on the lookout for those. And so you hate to get to the point where you're going to make an award and then disclosures need to be corrected. So if you can get them sooner and get those corrections happening, it'll make the award process go a little bit easier. So financial disclosures are, and this is exactly what I just completed a form for Dave's LLC. So in this example, this is probably the easiest example you're going to see. Vendor, and there's no parents. So these are required for contracts with an annual value of $50,000 or over. So for those small purchases that are less than $50,000, you're not going to have to complete these. These are only if it's over 50. So from the vendor name is Dave's LLC. The disclosing entity is also Dave's LLC. So that's important because when you have different parent companies, and as we go on, we're going to do a couple of these. That vendor name will stay the same because the vendor that you're contracting with is still going to stay Dave's LLC, but say Dave's LLC is owned by another company, the disclosing entity on the next set of disclosures will be different. And so, when we're answering these questions for these different nine of these different steps, whenever they need to put in the disclosing entity, it should match the front page as well as the following steps. Okay, in the instrument of ownership or beneficial interest, the vendor, if you see here, I've already selected limited liability company, but they have a drop down that they can choose. So they click into the drop down, they can select sole proprietorship, corporate stock, LLC, partnership, not for profit, other, or trust. Okay, so they select that, that's correct. And now we're going to walk through the 9 different steps. Step 1 is just the kind of the overarching category of what that company is. Is it a publicly traded company? Is it a privately held entity with more than 100 shareholders? And then it's going to provide the additional steps where you need to go. It's almost like a little bit of a choose your own adventure here. Option 3, all other privately held entities, not including sole proprietorship. Then it's going to say, hey, go in and complete this step. Foreign entities, if it's a not-for-profit or if it's a sole proprietorship. Mostly we see, obviously we have all these options for reasons, but mostly what we see is option 3, as this is all your corporations and your LLCs. So step 2, now this is where we're going to get the ownership information for your vendor. So I have Dave Luttrell, 401 South Spring. We have to have the address, and then the percentage of ownership versus the dollar value of the ownership. Now, it needs to be either one. You don't have to have both completed here. We're looking for everything that is in these disclosures come directly from the procurement code. Okay, so this form was built in conjunction with the code. And so what needs to be disclosed is the percentage of ownership. Many times you could have a few owners here that add up to that 100%, but we don't have to have the dollar value of the ownership and the percentage. Most of the time, you're just going to see the percentages completed here, and that is compliant with code. Okay, in this instance, Dave owns the 100% of the LLC. Now, our option B, or the table Y, that was table X, which is ownership, share, and distribution. The distributive income, also, if it's over you can see here, if you read it, the percentage exceeds 5% of the total distributive income, or the dollar value of the distributive income if the said dollar value exceeds $106,447. Now that's a very specific number, and the reason why that's there is that it is in the code. It's written as 60% of the governor's salary. So that distributive income, once again, if they have the 100% of ownership completed, they do not have to complete the distributive income. It's one or the other. Now, you could be in a situation, and we see this sometimes with when you have those owners that there's more than 20, or you have say I've seen it in architecture firms or partnerships where they don't own more than 5% of the company, but that distributive income is over $106,000. It is rare, but we do see that, and that's why we have the options here. Like I said, most of the time you're just going to see table X completed, and the ownership will be, one owner at 100, or two at 50, three at 33%, four at 25%, and on down. Okay. If that doesn't add up to 100%, we may need to go back to that vendor and confirm that the other ownership is all less than 5%. Okay. So you could have an instance where a vendor owns, or the ownership is set up that you have three owners at 30% each, and then you get to that last 90, so that's 90%. You get to that last 10, and maybe there are 5 owners that all own 2% or something like that. It could happen that way, and they wouldn't have to be disclosed here. We always want it to reach that 100%, because at that point I'm going to look at it and go, wait, maybe they didn't complete this correctly, so we need to go back to the vendor and confirm that anyway. Okay. Can you explain the definition of distributive income, or how a vendor would figure it out? Yeah, so it is essentially, it's kind of like dividends is if they, on a quarterly, if they're sending out shares, like dividends on the stock, that happens. That distributive income would be over the $106,000. Or if that's the way I've always understood it, is that distributive income is if they are receiving not just the ownership, but if they are receiving that income from dividends. So it's essentially like a snapshot in time of what, if the question we get a lot would be, hey, our stocks are changing all the time. How would we know if they're over a certain percentage or not, if they're over that 5% of the total distributive income? And the answer to that is, it's just a snapshot. Excuse me. It's just a snapshot in time. So it wouldn't, if it fluctuates from here or there, it just needs to be at one time there. So the certification, they have to certify that the following statements are true. They've disclosed all the individuals or entities that hold an ownership greater than 5%, and they've disclosed all entities that would need to be disclosed over the distributive income amount. Okay, so going back to that answer, or the question that I had in terms of what we see if it doesn't reach the 100%, yes, they have said that they've disclosed all the individuals that would need to be over, but in my understanding and my experience, I've seen many times where, yes, they check that box, but when we go back and say, hey, look, are we missing any ownership here? 9 times out of 10, they didn't complete it correctly. So we would have to go back and just double check. Okay, so option B, now this is the disclosure, and this is only for not-for-profits. So in that step 1, if it was a not-for-profit, the not-for-profit instructions would say, go to step 2, option B. And so for our board of directors, we just need the name and address of the board of directors, and the address can be the address of the not-for-profit. We don't have to have their personal address. That question comes up every once in a while. Okay, we get to step 3. Now, step 3 is disclosures of lobbyists, and this gets misunderstood sometimes. It's not just that is your company represented by, or do you employ a lobbyist that's required to register under the Registration Act, but it's this, I want to highlight this, and who has communicated, may communicate officer or employee concerning the bid or offer. Okay, so they have to have a lobbyist who has worked on this procurement. Okay, so sometimes you'll run into some companies that, yeah, they've hired a lobbyist, but it has nothing to do with this procurement, so they wouldn't necessarily have to be disclosed here. It is those lobbyists that has been working on this procurement. Now we get to step 4. Now within the prohibited conflicts of interest, these are relationship questions. I'm not going to walk through every single one of these, but for instance, do you hold a seat in the General Assembly? Do you have a spouse or immediate family member who's been appointed as a member of board commission created by executive order of the governor? They have to answer these questions. Okay, so they would mark no for each one of these, or if the answer is no for all of these, you don't have to have, say there's multiple owners, you don't have to have completely different step 4s for all of these. They could just be listed. If we had multiple owners, they could be listed there if the answers are all no. Now, if you maybe have one that is answered yes, that's okay. You have to click yes. And then in step 6, you're going to explain more of that further. So where it's going to talk about that in the next couple steps, where you're going to explain exactly what the nature of those relationships are. So step 4, in this case, we just have the owner. Step 5, moving forward, similar, but now they're different types of questions. This goes to a little bit more. There's a potential conflict of interest where, it's, a lot of where we see these is, for instance, do you have state employment? Do your spouse, mother, son, daughter had state employment in the last 2 years? Now, there could be a potential conflict of interest, and we're going to talk about what happens if any of these are answered yes, but they don't. It's not. Let's give an example. So, my wife, let's say my wife works for DNR, and this is a do-it contract. Now, yes, there's a potential because my wife has state employment. However, in the case once we would look into that and complete a conflict of interest review form, the SPO could look at it, or the CPO or PPB, depending on how this works out. And we're going to walk through that form as well. It could potentially have absolutely nothing to do with the do it contract because my wife works for a completely different agency. But however, they could be, if this was a DNR contract, and I do have some sort of authority as a part of the award process, there could be a potential conflict of interest there. Okay, so the vendor will answer each one of these questions. And just as a side note too, if any of your vendors are in IPG, the Illinois Procurement Gateway, these are the same exact questions. So these questions mirror the IPG question. So in this case, the answer is all no, and we could move forward. But let's say, what if one of these answers was yes? Okay, maybe in the example we're giving, my wife works at DNR. So in step 6, this is the explanation of affirmative responses. So this is where they're going to provide an extra, they can either type it in here or they can provide an additional page that it needs to have this information. So the name, the salary, the state agency or university, and the position title of each individual. And this is important because first of all, that's what the code says, so that's exactly what this form is going to do. But the reasoning behind it is, as I discussed before, perhaps there could potentially be a conflict of interest if I'm awarding a contract to an agency that my wife works for. Okay, so if that answer is yes, you'd either have that information typed here or a separate document that has all that same information, the name, salary, agency, and the position. And then what happens is you're going to complete a conflict of interest form. And so let me go out and show you what that is. No good time like present, or no time like the present, just to show that. And it's in our resources library, procurement resources library, but it is also a PPB document. So it's on the Procurement Policy Board's website. but we also provide a link to it in our solicitation and contract templates. At the very bottom, we have a conflict of interest review request form. So it takes us the link to it, conflict of interest review and determination form. And let's walk through this quickly. So the agency will complete this and then submit it to the SPO. It has just some of the general information here, the name of the vendor, describe the proposed contract, some of the information in terms of the contract renewal amount, whether it's estimated or not, is this with a prime or a sub? And then on the second page, this is where essentially you could copy and paste from what they gave you. So this is, the name of the individual, the relationship, all the information that's here as a part of the potential conflict of interest. And then as the SPO, so you complete the entire form, send it to the SPO. Now there are 3 different tracks here. So the SPO has the authority to look at this and go, no, I took a look at this. I do not view the relationship disclosed as creating a potential conflict of interest. Okay. So they can check that, they sign it, and then if they look at it and they're not sure, we can elevate it to the CPO. So you can see the SPO to forward the materials to the CPO. If the SPO finds a potential for a conflict of interest, they can refer it straight to PPB, and they send it to these emails. Okay, so there's a couple options there. The SPO can look at it and immediately say, look, no way, there's nothing to see here, there's no conflict of interest, and sign it, and you can move on. Or we can elevate it to the CPO's office if we're not sure, or if we do see a conflict of interest, we refer that to the procurement policy board. Okay. So going back to our example here, we're going to say that there was no, most of the time you're going to see no, but in my experience, the ones that I see the most yes answers to are the, sometimes they will look at the board or commission, and it's the vendor is on the library board or some park board in their town or city, and it is technically that could be marked yes, but that doesn't make a conflict of interest for that particular contract. But it always could. So that's where the difference between the steps 4 and 5 are. You need to take a deeper look at those step 5s. Okay, so we get to step 6. We talked about step 6, and that's only if there are yes answers. And then we get to step 7. Now, step 7 is potential conflicts relating to debarment and legal proceedings. So these questions are not about relationships. These are specifically, have you had debarment? Have you had any professional licensure discipline? Have you had any bankruptcies? So these go to responsibility. So when we talk about awarding to the bidder or offer that is responsive and responsible, right? Most of the times when we talk about responsive, we're talking about does it the actual specifications, and does it meet the requirements within the actual procurement? Whereas the responsibility goes to can they, if we have a big project and they just declared bankruptcy last year, are they going to be able to fulfill that contract? That's where the responsibility, and that's where step 7 comes in. So, and at this point too, I'd like to bring up a something that gets misunderstood quite a bit, and I want to be able to clarify this. So this step must be completed for each person disclosed in step 2, step option A, step 3, and for each entity and sole proprietor disclosed in step 1. So this is anybody and in any entity that is disclosed in that option X or table X up here in option A. So any person or entity that you see up here in table X as a part of that ownership needs to answer those questions in step 7. And so you say, well, Dave, this says person, right? And full disclosure, I was confused by this as well. So if this is, hopefully a light bulb will go off for some of you today. For each person. Now this is, like I said a few times, this form was created using language from the code. So let's go out to the code, and you can we'll look at the definition of person. Let's see. I had it pulled up, but I had to answer another question earlier. Sorry about that. Uh, where'd it go? See, this is why I shouldn't multitask 2 minutes right before a training, right? There it is. So person means any business, public or private corporation, partnership, individual, union, committee, club, unincorporated association, or other organization or individuals or other legal entities. So person means all those things. In the past, so person does not mean individual. Person means all of, any entity, any organization. So when we go back to our step 7 here and it says complete for each person, just make sure that anybody and any entity, so we could, in our next example, you're going to see that we'll have multiple owners. They all need to be listed in step 7. Plus, so the difference between step 7 and step 4 and 5 is in step 7, you also need to have the entity. So you can see here it's Dave's LLC, because we are asking these questions specifically about that vendor as well as any owner of the vendor. Okay. Step 8 is the disclosure of current and pending contracts. So if they if they have other contracts that are with an annual value over $50,000, they would need to be disclosed. So, but it wouldn't. They don't have to disclose the procurement that they are bidding on. This is only for other contracts that they hold above with an annual value above $50,000. Okay, and then we get to step 9, and this is very important because that name of the disclosing entity, this is another box that it says in red, click here to enter text. You need to go in and the name of the disclosing entity. So the name of the disclosing entity is going to match the very first page as well as here in step 9. So they are saying for this set of disclosures, this is the name of that disclosing entity. And then it needs to be signed, dated, and you fill out the rest of the form there. Okay, so that's the most straightforward one. I'm not going to walk through every single one of the steps, but I just want to highlight a couple things that would be a little different for maybe Dave's LLC is owned by another company. So let's do that right now. So I'll walk through this one, and then I'm going to do one more after this. So essentially, this is the first one was the vendor, which is very easy, 100% owned by one person. Now this is a vendor that is owned by another company. Just to confirm, vendor does not have to list the contract bid for which it is submitting the form. Yes, correct. Yeah, I might have not said that in the clearest way possible, but that step 8 for the bidding for the pending contracts and bids, it's only if they have other contracts or bids. It's not for the one, because obviously they're already, they're submitting for the procurement that we are working on. Okay. So this is for a vendor. And then you can see the vendor name, Dave Jordan James Corp. The disclosing entity is Dave Jordan James Corp. But now we have a parent company. So, and since this is, Dave's training, I get to, go into business and with some of my heroes. So, Ozzie Smith Holding Company owns Dave Jordan James Corp. Okay. So step 1, the option 3, this is, once again, it's all other privately held entities. I get to step 2. Now you can see that Ozzie Smith Holding Company owns Dave Jordan James Corp 100%. So at this point, you know that we're not going to have multiple owners. We have the 100%. So we already know at this point we're going to have a whole separate set of disclosures for Ozzie Smith Holding Company. Hold on just a second. I need to mute somebody. Thank you. Right. So at this stage, we know step 4 and step 5, there are no relationships, right? So step 4 and step 5 are those questions where we're talking about, does your wife or spouse, child, all those relationship type questions. We know we're not going to have any of them in there because this is owned by 100% another company. Now, those questions are going to be answered on the next set of disclosures, but not particularly on this one. Once again, they have to certify that these are here, right? That they disclosed all the individuals or entities that own the ownership graded. They did already. This isn't a not-for-profit, so it won't be option B. Step 3, we talked about step 3. It's only if there's a lobbyist that was working on this particular procurement. You can see here, sometimes they will actually mark no, or they'll put not applicable or something like that. And that's perfectly fine at this point because we don't have anybody that would potentially have those relationships just yet. Step 4, step 5. Now when we get to step 6, it would only be if there were any yeses, but there wouldn't be, right? That wouldn't really be applicable at this point. Then we get to step 7. Now they will need to be disclosed because once again, in step 7, we are talking about the actual entity. So this is the Dave Jordan James Corp. Do they have any bankruptcies, adverse civil judgments, etc.? Step 8, same disclosure of current and pending contracts. And then the step 9, that once again, that name of the disclosing entity is really important because this is where they are, they are signing this for this company, under the penalty of perjury. Some vendors will be cute sometimes and they'll actually like cross this out, which I've seen, which is kind of funny. They can't do that. They have to sign it as is. They can't go in and mark this up and then sign it. Okay, so that's one set of disclosures. Now we know that it's owned by 100%, or it's owned 100% by another company. So we're going to have another set of disclosures for that Ozzie Smith Holding Company. And that can continue. Many times you'll see multiple levels like that. The next set of disclosures is Ozzie Smith Holding Company is owned 100% by another entity, which is then owned 100% by another. So rather than, go through all of that, I'm just going to go through the ultimate parent. So you could have 3 or 4 of those, upwards of 5, 6, 7. I mean, we see some that are very complicated. And we get to the ultimate parent. When I say ultimate parent, all that means is this is the final where the 100% ownership breaks. So at any point where there's less than 100% ownership, that will be the final set of disclosures. Okay, so here you can see this disclosure is submitted for vendor's parent entity or entities. Once again, this vendor name is going to stay the same across all of these. Okay, so the vendor name is still Dave Jordan James Corp. Now, the disclosing entity for this set of disclosures is Ozzie Smith Holding Company. Instrument of ownership, remember they use the drop down so they can select. This is corporate stock. Step 1 is still that same option 3 for our example here. When you get to step 2, now we're going to see where it starts to break up a little bit. Okay, so our ownership, Tom Brady LLC, Walter Payton LLC, The Wizard LLC, and Willie McGee as an individual are our ownership group. So at this point, we know we're not going to have any other sets of disclosures because we don't have anybody or any other companies that own 100% of this company. Okay, so we kind of know that off the bat. But now what I'm looking at, I'm thinking immediately, as soon as I look at this, okay, Tom Brady LLC, Walter Payton LLC, The Wizard LLC, and Willie McGee, I know for a fact all 4 of these are going to have to be on step 7, right? Because step 2, all the ownership is going to match step 7. But those steps 4 and 5, those are going to be for those relationships. So I know Well, Willie McGee as an individual is going to have to answer those questions, step 4 and step 5. But the LLCs, they don't. So as I scroll down through, right, we don't have to do the distributive income if we have done the ownership. But for instance, this once again could be, it could be set up in a way that the distributive income is over that $106,000, but it's less than the 5% ownership. It is fairly rare, but we do see it. They certify that they've disclosed all the individuals or entities that are required to. It's not a not-for-profit, so you're not going to see anything there in option B. Lobbyists, we talked about lobbyists. Now we get to step 4. Now provide the name of the person for which the responses are provided. This is Willie McGee. Now the answer, why do they not have to have Tom Brady LLC or Walter Payton LLC? Because those are companies, they're not going to have these questions. It's not going to be not applicable to them. But any individuals would need to be a part of here as well. So the answer to each one of these is no. Of course, if the answer was yes, you're going to see explanations in step 6. So step 4 and step 5 are similar in this example because we have that one person. So Willie McGee is listed here. Step 6 would only be if we had any affirmative responses to those questions. Now we get to step 7. Now we're going to have Tom Brady LLC, Walter Payton LLC, The Wizard LLC, and Ozzie Smith Holding Company. So this is probably one of the things that we see most often is overlooked is the actual disclosing entity needs to be disclosed in step 7 as well. Okay, so for step 7, remember this is where we're talking about bankruptcies and debarment and licensure discipline. That does apply to all of those entities. I'm going to scroll back up to table X in step 2. So that always needs to match. Whatever's in step 2 here, the ownership is going to match what's in step 7. But in step 7, you also have to have that disclosing entity because at this point, the Ozzie Smith Holding Company, as I scroll down further, Ozzie Smith Holding Company, which is the parent company, and the disclosing entity here has not answered any of these questions. So that's why that needs to be there. Okay, step 8, they don't have any current or pending contracts. And then in step 9, once again, that name of the disclosing entity needs to be listed here because this is where they're signing step 9, that has to be listed in the name of the disclosing entity so that, like we talked about, all of this under here, disclosure signed, made under the penalty of perjury, et cetera, et cetera. Okay, so at that point, we've gotten to the end of the ownership, where that 100% breaks. So there will not be any more financial disclosures. Let's see, what was on one of our other options? Let's see what the multiple LLC one. Oh, this is just another example of, sorry, let me start. This was if a vendor isn't owned by 100%, but it's owned by multiple owners. So in this case, you can see the vendor name was Dave Jordan James, LLC, disclosing entity. Now there's no parent, but as we scroll down and look at that table X, you're going to see that it's owned by 3 individuals. It's the same exact idea as 100% individual. It's just, here's just another example of what you'll run into. And so in this case, where we have 3 owners of the LLC, that table X, once you get to table or step 4 and 5 and 7 are going to have to be answered for all 3 of these individuals. That was it. I was just trying to think of the difference between the previous example and this example. And this is just where, you can see where the percentage is broken down. It goes up to 100%. And so as I scroll down, I'm not going to we'll go all the way through here, but here's an example of step 4 where I have Dave Luttrell, Michael Jordan, and LeBron James because we need these answers for each one of the owners. Okay. Step 7, here's an example of you have the actual LLC, Dave Jordan James LLC, as well as the owners of the LLC. Okay, so I think I've gone over the 3 most common ones. See if I missed one. Oh, the sole proprietor. The only difference with the sole proprietor is they don't have to mark 100% because if they are the sole proprietor, they don't have to mark that they're 100% owner in table X because as a sole proprietor, that's exactly the definition. So that instrument of ownership is going to be listed as sole proprietorship. And as you see on step 1, this is the first time that we have a different box checked, which is option 6, sole proprietorships. And so it tells you to skip step 3 or skip to step 3, sorry. Because as I said, step 2 has that ownership share. The definition of sole proprietor is that you're the 100% owner. So not to be confused with an LLC that's owned by one person, a single member LLC, because that's also very common. So now let's go back and we'll go back to the slides here and just pull up the most common corrections that we see that are needed on disclosures. So number 1, not disclosing the proper entities or people in step 4, 5, and 7. A lot of times they're even just blank. I mean, that's kind of the real low-hanging fruit there you can easily grab. I mean, that's easy to see if you look at disclosures and there's nobody listed or no entities listed for steps 4, 5, and 7. That's one of our, obvious ones. Number 2, we talked about this, was the disclosing entity is not disclosed in step 7. That's probably the one correction I see the most, is that the disclosing entity isn't disclosed in step 7. Number 3 is where we're talking about the difference between sole proprietor or single member LLC, is a vendor completes disclosures as a sole proprietor when they're technically a single member LLC. Many times a vendor may just be slightly confused on what they are. They think they're a sole proprietor, when really, no, they are a single member LLC and the forms need to be completed as such. Number 4, not disclosing in step 9. So that's the very last step where they're signing. This disclosure on information is submitted on behalf of, and then that's blank. That needs to be there. Number 5, they don't sign it. There's no signature. That's going to be a must before we're going to be able to move forward. And then number 6 is a little bit more prevalent in the leasing world. So you don't really see it with other agencies, but a trust doesn't list all beneficiaries or the trustee. But certainly we run into that outside of leasing as well, but it is pretty common in leasing. Whereas they have a trust owns the building, but they don't list all the beneficiaries or the trustee. So those are the most common ones. Everything else, there are going to be specific questions moving forward, but I think it was just a good time to take a look into a quick, I know we only did maybe 35 minutes or 40 minutes of this. This could be a much deeper training. And if run into questions regarding disclosures, reach out to your SPO, your APO, all those. We want to be able to get those. I guess as a helpful tip or hint is, get those disclosures soon and have those reviewed as quickly as you can. You hate to get to the very end of making an award and then you have to go back and do a bunch of corrections. So that would be one of my tips. And another one, I think it goes without saying, but have your vendors registered with IPG, because the IPG team are vetting these every single day. The same exact disclosures have to be completed and filled out. And so if the vendor is using Forms B and in IPG, that's going to make this process go that much quicker. All right, so I don't have any fun fact of the day, although at 8:58, when I looked it up real quick, it's National Redheads Day. So, hug your redhead. I will send this out as usual as a part of a recording and the slides, even though we only just have a couple here. But let me make sure I didn't miss any questions. I think we're good. All right. Have a fantastic Tuesday, everybody. Appreciate it.